All right, guys, thanks for your time today. I know it's lunch hour for most of you, and for some of you on the East Coast, it's in the afternoon. So, for those of you that don't know me, I'm Cherie Harrington. I'm a real estate agent here in San Diego. Welcome to our Zoom training today. We're going to talk about the importance of estate planning. So, I'm joined today by Colleen Robinson, who's an estate planning attorney, and Cassie Winterroud, who's a mortgage advisor. So, this topic is one that a lot of people prefer to avoid, but it's essential for protecting yourself and your loved ones. So estate planning, no matter what your income or asset level may be, ensures that your assets are protected, your loved ones are provided for, and your wishes are carried out as intended. So a lot of people think this is just about protecting your family, and it is. A lot of it is, but when you're gone and you haven't let the people in your family know what your wishes are, that's a problem, right? So this is going to be an open discussion today, and we encourage you to type your questions into the chat as we go, so that you leave here today feeling completely comfortable about how to approach the subject with your loved ones and understand the next steps going forward. So before I turn it over to Colleen Robinson, I wanted to give just a few minutes to Amy Van Ling, whose husband recently passed away unexpectedly, and why she thinks this is such an important topic. So Amy, I'm going to turn it over to you.
Thank you, Cherie. Yes, we just met recently at my husband's funeral. Our husbands work together, so I'm here to give this quick personal share because it's quite on point for this discussion of estate planning, which we did not do. So I'm here to share with you that the unthinkable, the unimaginable, the unbearable tragedies in life do happen, and not only to other people, as we often like to believe, because, well, it's more comfortable to think it happens to other people and not imagine the worst, case scenario for ourselves or our family. And yet, if a fatal situation does strike your family, you will definitely want to be prepared, because I am living what is not being prepared, and it's not pretty. My husband, Mitch, was 55 years old, and he was killed 7 weeks ago in a tragic motorcycle accident. He was healthy, vibrant. We have four wonderful children. Our youngest is 15. Our granddaughter's 18 months. He was our rock. He was living life to the fullest. We never imagined that one day he would just not come home. Car crossed over the line, not even his fault, on Sunrise Highway out in Pine Valley, and he had to make a split-second decision whether to hit the car head-on in his motorcycle or to try to save himself, which he attempted to do. But because of the velocity and the trajectory, he ended up being catapulted down the mountain and died almost immediately on impact. My 15-year-old and I were on the phone while the paramedics were trying to revive him, and they could not. So it really is the most unfathomable tragedy like this that you never expect. But in that moment and moments to follow, your body is in total shock, complete cognitive malfunction, emotional distress takes over. And in this state, it's nearly impossible to make any important decisions. Yet at the time of death is suddenly when you have to find closure and wrap up the life of the deceased. It seems very unfair, but that is just how it all lines up. So I was thrust into this situation 7 weeks ago without life insurance, without a will, without a living trust. I had unlimited power of attorney, but it becomes void at the moment of death. And I had to quickly decide about burial, cremation, property worth, what to write on the headstone, gather information for the death certificate, the smallest things like occupation title. My husband had many titles, and abruptly, under massive major duress, I had to fill out official forms, forever documents. And I wasn't even sure exactly what he would want to have on them. So this added immeasurable stress. My name wasn't on most of his physical property because it was just easier that way. I dealt with my things, he dealt with his things, and we were going to live, until we were 93. And I didn't and still don't have access passwords. I don't have access to our children's 529 accounts. It takes a process. I will get them eventually, but I continue to be in the midst of what I call shoveling out of the avalanche of disaster that hit my family. And so I am here without any personal gain or any personal incentive to just say it's wise to plan. It's wise to have these seemingly strange and morbid discussions now. You know, may you never need this safeguard due to a tragedy like mine. But the truth and the reality is that we will all have a last day on earth, and you will indeed leave loved ones behind at some point. And so if you take the steps now, you can ensure that the grieving process for your loved ones can be focused on memories and healing, you know, providing them with a space where they can avoid that additional anguish, you know, having to make those important life-altering business decisions in a state of shock and grief, which is nearly impossible. And as well as ensuring that your family won't face, you know, financial ruin or financial despair, which I'm actually face to face with right now. It's quite devastating. So I encourage you to get the details of life and death ironed out now while you are living, before death. And I imagine this will also help you live more securely and peacefully, because I know that's what I'm doing now. And it brings me security and peace to know that if anything should happen to me, my children won't have to go through what I've been dealing with and probably will be dealing with for many months to come. So that's my share. Thank you for giving me this time to be with you this afternoon. And in advance, forgive my early departure in just a few minutes. I'm on the East Coast and my daughter's getting out of school and needs to be picked up. So thank you so much for your time. Thanks,
Thank you.
Cherie, for inviting me.
Thank you, Amy. And I appreciate this because I know what you're going through. And Colleen and Cassie and I have been talking a long time about doing a Zoom training on this. And when I physically saw what you're going through, I'm like, this is the time. So thank you for being on. I appreciate it. All right, Colleen, I'll turn it over to you.
Thank you. Amy, thank you so much for sharing your experience in this space. As you just talked about, it's not something that we ever foresee. We know about it and it's easy just to brush it off. But I think that talking about what it really looks like when there isn't a plan in place is so important. And I could be up here and tell people that, but hearing personal stories, I think just makes it more not palatable, like tangible to understand. It's not just talking head talking about why it's so important to do that. So I'm going to share my screen here in just a second. And I hope that the presentation today is going to make this not only interesting, but you're going to walk away. My goal is that you're going to walk away with a better understanding of what is estate planning, why do you need to care about estate planning, and what are your next steps, most importantly, because the last thing that I ever want to do is to leave anybody hanging. And that anxiety of what do we do now? I would never do that. So we're going to provide those next steps and how to take care of this for your family. I am licensed here in California, so I understand that Cherie's got some clients or some contacts that are located elsewhere in the United States. Welcome, regardless. This is the basic enough information that it's not super California specific. If you are located outside of California, I have lots of contacts within estate planning to hook you up with an attorney in your area that practices similarly to me. So please don't hesitate to reach out, even if you're outside of California. So we're talking about how to protect your legacy, most importantly, how to create a legacy. And that word legacy is such a loaded phrase. What does that mean? And that's an individual definition to all of us. Maybe it's wealth building, maybe it's the values that you share, maybe it's experiences, maybe it's charity work, whatever that is. Having the ability and the tools to create that, I think, are so important. But I also just want to take a minute to thank Cherie and to thank Cassie for providing this forum to have this discussion today at lunch. So I'm going to get right into it. So anytime you hear me talk about or say the word court, it doesn't matter, like even when we leave today outside of this webinar, anytime you hear the word court, whether it's criminal, traffic, civil, you name it, it applies. This acronym applies. CCD. That's cost, conflict, and delay. We're going to talk about the cost of not having a plan. We're going to talk about conflict. Conflict does not always mean people fighting. It could be the internal conflict. And when we're talking about probate court specifically, there may not always be another opposing side that we're fighting. It's the internal conflict, the internal stress of one, having to go to court. Two, am I doing this right? What am I doing? The hearings that you have to appear in. What is the judge going to say to me? And I just don't know what we're supposed to be doing. And why is this taking so long? That delay. In California, I know it may be shocking to a lot of people. This is not a probate-friendly state, meaning that it takes 1 to 2 years for your assets to go through the probate process. And we're going to talk about the cost that's associated with that 1 to 2 year process as well. And that 1 to 2 years does not apply. Like when I say that, I don't want people to think, oh, well, it's only for the wealthy that it takes that long. With people with lots of assets, it's even longer. So that's like the average, household going through the probate experience or going through the probate process is that 1 to 2 years. So the questions, like rhetorical questions, or feel free to put them in the chat if you're comfortable doing that, is do you currently have an estate plan? If you don't, why don't you? These are the common reasons that I hear is that I'm too busy. I get that, trust me. Got 3 little kids under the age of 6. We're too young. We don't need to think about those kinds of things. I think it's too expensive. And I'm hoping by the end of today that all of these things that you'll see that I need to have this. This is something I need to have regardless of how busy and how complicated life sometimes gets. If you do already have an estate plan, then maybe you're wanting to have a better understanding of how it works. Maybe you did something online like LegalZoom or something along those lines and you're wondering if it's okay. Or maybe it's just something you did a long time ago and it needs to be updated or you have questions about it too. So if any of those apply, you're still in the right place, because after all, this process, estate planning, is protecting something or someone that you care most about. Because the reality is with this, like estate plan is kind of an odd place to put your brain, planning for when you're not here. But the reality is it's not about you. Yes, you get that secondary like feeling of accomplishment and that peace of mind that you taken care of it. But it's about those people you leave behind, because they are the ones that are going to know whether you live up to that promise that I took care of things. So we're going to give you all the details, how to start, how long does it typically take, and how much does it cost here specifically in Southern California. So this is how this is going to work. I'm going to share a story and a specific incident of 3 different characters. And each character has different things that are going on, so we can explore different topics within estate planning. And I'm just going to put it out there. When we talk about scenarios in estate planning, they are not happy stories. So I don't mean to be triggering. I don't mean it to be sad situations, but that's the only way to make this, I think, more interesting and more applicable to your own lives, because you may see yourselves doing some of the things that these characters did as well. So let's meet our characters. They were all involved in a car accident. I'm going to show you who they are. So we have one Tom truck driver. We have the Doe family here, and then we have Mama Molly. And what happened is that we have Tom the truck driver. His wife passed away a few years ago, and they have a 16-year-old daughter named Delilah. And you're going to see real soon that my character names are not that original. So Tom truck driver, daughter Delilah, if you see where this is going. Tom is on the road a lot because his wife has passed away. Now he's the sole income provider for the family. You could imagine being on the road. He doesn't have a great healthy diet. And he has a heart attack driving and causes this 3-way collision. So he dies immediately. The Doe family's unresponsive, and Mama Molly comes as she's an innocent bystander and tries to render aid and is hit by another car as well. So let's just go and focus on each one of these families in turn. So Tom, the truck driver, as I mentioned, he has his 16-year-old daughter, Delilah. And what Tom does is he goes and he purchases a life insurance policy of $1 million. And he lists his wife as a primary beneficiary, and then he lists his daughter Delilah as a secondary beneficiary. So Delilah, aside from just losing her parents, she's like, oh my gosh, I'm gonna be a millionaire. I'm gonna go and move, out of our house, and I'm gonna go get that beachfront property because I can do whatever I want with this money. Maybe I'll stop going to school and just do it online or whatever, but I don't need to do anything any longer. The problem is that what most people don't realize, especially with minor children, is that when they list them as beneficiaries to like life insurance and retirement accounts and even brokerage accounts, minor children cannot inherit. So what happens is, and especially in Tom's situation, what he's done is he opened the door to 2 different kinds of court proceedings involving his daughter. One, without any guardianship nominations, we have a guardianship over the person. She's underage. Somebody needs to be in charge of her. Then it's the money. Who is going to manage this money on her behalf? That's called the guardianship of the estate. There are 2 different types of proceedings, and they have different types of requirements as well. So in this situation, we have Tammy Teacher. She truly cares about Delilah. She sees her every single day, is concerned about whether or not she's going to finish school. She's gone through so much trauma. She's offered to take care of Delilah so she can continue mentoring her and make sure that she graduates high school. Well, that sounds quite lovely. What a nice person she is. So if she were to call my office, I said, okay, great. We're going to have to file a guardianship of the person, a guardianship of the estate. You're going to be subject to a credit background check, a criminal background check on all this paperwork that's required. A lot of people don't realize how invasive this process can be, because the idea what the court's trying to do is just to gather as much information and have a basic procedure on how to determine who is going to be the best person to care for this child's money and this child's person, in so many words. So then we have Aunt Stacy. Aunt Stacy lives up in Sacramento, let's say. She hasn't seen Delilah in over 10 years. She hears about her brother passing away. She's like, wait a second. If this child should be with anybody, it's me. I'm blood relative, and I should be managing that money as well. So if we were the probate judge, which in San Diego County, there's only 4 of them, who would the judge choose? Tammy Teacher with the relationship with Delilah, or the estranged aunt that hasn't seen Delilah since she was like 6? The answer is, as this guy is aptly pointed out, is that we truly don't know. There is wide discretion amongst the judges in these types of decisions. So you could take the same set of facts, go down next door and get a different result, go down the next department and get a different result as well. So truly, and I tell this to clients, once we walk into those doors, into those courtroom doors, we're no longer in charge. It's the judge there making that decision. And the reason why I mentioned 4 judges, in probate, they have each one of those judges are deciding guardianships. So the state and over the person, they're deciding conservatorships. If there's adults who can't make their own financial and medical decisions, they're doing estate administration and also trust litigation. It's a huge caseload for 4 people. So they are spending fractions of time in making these extremely important decisions just mathematically. So as I mentioned, we just don't know who he's likely or who she is likely to choose. So going back to this teenage millionaire situation with daughter Delilah, let's see how we can fix this story for everybody involved. So situation number 1, and I hear this a lot, why don't we just Tom leaves the money to his sister Stacy and says, I'm going to leave you the life insurance policy because I know better. I shouldn't leave it to my minor child. I'm just going to leave it to you. And you know that when you get that money, that's for the care of my daughter. She's like, sure, Tom. If I could make this blinking lights flashing at everybody to say, do not do this, it absolutely would. And the reason for that is not because we don't trust Aunt Stacy. It's just that money is legally hers to do whatever she wants with. And we do not have a crystal ball. What if Aunt Stacy, even under the purest intentions, what if when Tom dies, she has huge financial hardship? She just lost her job. Her husband's in the hospital. They have surmounting medical bills. They're gonna lose their home. Like there could be real life situations, not just like purely evil. Like I'm just gonna use this to go on a cruise for a year by myself and not use it for my niece at all. It could be that way, and it could be that this situation I just described as well, that she uses it to buy a bigger house, to go buy the boat she always wanted. Legally, it's hers to do what she wants with. Morally, that's a different situation, but legally, it's hers to utilize. So she doesn't have to utilize that for Delilah. So I always caution people with that. Situation or idea number 2 is that Tom signs a will. So he says, you know, all of my estate to my daughter Delilah. If she's under the age of 18, then my sister to manage it for her. There is a big glaring problem with this. And this is that a will is overridden by joint ownership or beneficiary designation. Like, what does that mean? Beneficiary designations on those retirement accounts, those life insurance policies, the brokerage accounts, for example, and even how we own title will trump our estate plans. So I'm going to give you a real life example here, is that I was involved in a family law case a while ago, and it was very contentious. We represented the husband, and in the divorce, he got his life insurance awarded to him. So it was his to do whatever he wanted. Shortly thereafter, he got sick, and he executed what is called a bedside will or trust. I don't remember which one it was, because I'm going to tell you it doesn't matter why I can't remember that particular detail. So he executes it in the hospital because he knows he's about to die, and he leaves it to his adult sons. He passes away. He names his brother as the executor or the trust successor trustee, who calls a life insurance policy or a company. He's like, my brother's died. I'm calling on behalf of the estate. I'd like to collect the proceeds on behalf of my nephews. The life insurance policy says, sorry, that money's gone. We've already paid it out. And he said who. And I don't know if anybody wants to take a guess who received that money. It was his ex-wife, because he never updated his beneficiary designation. So those are the marching orders to the financial institutions. It does not matter what's in your will or with your trust if it's not in coordination with those beneficiary designations, or even how you own title in real property as well. A lot of people do not realize that. So if we talk about your assets, so when someone calls and tells me that they passed away, before I even ask if there's a will or trust, these are the things I go through first. What kind of assets did that person own that they may have owned with another individual, and how do they own title? What assets has a beneficiary designation on it? And then finally, any assets that are not like jointly owned by anybody, any beneficiary designations, now the estate plan, whether it's a will or trust, controls. So surprise number 1, your probate estate only includes the things that did not pass to the surviving joint owner or your designated beneficiaries. So I hope that makes sense to everybody. If you have any questions about any of this stuff, just drop it in the chat so I can clarify. Surprise number 2, which most people, I hear this a lot too, is a will goes through probate. When you have a will, the only place for it to go is probate court. It does not avoid probate court. It also does not make it go any faster, and it doesn't cut any costs. All a will does is state what your wishes are and how you want your assets to be distributed. Otherwise, if you die without a will, have no fear. The state has a plan for you for your asset distribution. Some people like that, some people don't. But the cheesiest thing that I'm going to say, because I want you to remember it, if there is a will, there is a probate case. Because there's the only person that can validate that says this is the will of John Smith is that probate judge, and the only person that can approve the distribution order inside the will is a probate judge as well. So this is our probate process here in California. So this is where it would be a little bit different in other states as well. So as Amy even said, and when she introduced herself, is that powers of attorney, they extinguish upon death. So that happens right at the get-go. When someone passes away, then you need to open the estate. You need to file a petition at the courthouse. This is not something that's done right away, right? Like, because you also need to get a copy of the death certificate, which can take weeks to obtain. So, and you got to do the funeral planning. Like, these are not the very first things that you wind up doing. So once you file that petition and you finally get that court order, which is a hearing, it's usually 3 to 4 months once you file, but that might be 5 to 6 months after somebody's passed away. So when you think about a house, for example, that someone have, I always say my great aunt Sally. I've never had a great aunt Sally, but she's going to be my example in this situation. She dies without a will or even with a will, and she's leaving that house to me. If she has a mortgage on it, even if she had a bank account with $1 billion, I'm not listed on that account. My power of attorney is useless at this point. I can't access her bank account to pay the mortgage or the property taxes or the utilities until I get a court order, which may be 3 to 4 months since you file. So what about, am I in a position to pay for her mortgage along with my own mortgage and my own living expenses? Like, if that were in real life situation and this were me and I pass away with my brother, would my brother choose my house over paying for his house? The answer is no. I know that. A lot of homes are lost to foreclosure or in the foreclosure process just by virtue of this waiting process. The other thing that a lot of people don't realize, you have to put an ad in the physical newspaper when you open a probate case. And it has to be in a paper of wide circulation. So the legal field in and of itself, we're still like decades behind the rest of the world, that you have to put a physical ad in the legal classifieds. And then you have to like cut out the ad and send it to the court to show them that you actually did that. So then it puts on notice any creditors or family that may think that they've got a card to play in this case as well. And then finally you go to court, and hopefully your documents are filled out correctly, and you get that court order, which you then can take to the bank to get access to Aunt Sally's accounts, or being able to, it's called gathering the assets or mustering the assets, getting them and figuring out what she has, what's a part of the estate. Then finally, you can sell real estate. So you'd be talking to Cherie, and depending upon your documentation, you may have, everything is court supervised with the probate department. So even selling real estate may require judge approval. It just depends on the paperwork that you wind up filing. And then finally, the estate is in a position to get distributed or to get finalized. And like I said, in California, it's 1 to 2 years. So who gets paid first? Does anybody want to take a guess? Somebody's got to take a guess. I'll give you a clue. It starts with an A.
Attorney.
Yes, attorney, but also the executor. So attorneys and executors are paid equally, and that's determined upon a chart that our legislature has approved depending on the value of the estate. So as the estate increases in value, the fees that are earned by the attorney and the executor also increase. The next person that gets paid are probate referees, which is a court-appointed appraiser. Their job is to appraise everything that the decedent owned, real estate, go into the bank accounts, their stuff, their vehicles, because they've got to fill out schedules that get filed with the court. And then it's our creditors get paid out next, and then it's our beneficiaries. And any beneficiary under the age of 18, they just get a lump sum of whatever it is that they have. So if you could imagine you were 18 years old and you may be in a position to inherit even $100,000, how would have that impacted your decisions as an 18-year-old doing what, like going to school or starting a job? What kind of job would that have been if you have done that? And then also it's 5% the value of the estate to go through this process. 5% may not sound like a whole lot, but it adds up rather quickly. So, and I'm sure Cherie could give me a more updated number, but when I last looked up the average home value in San Diego County, it was roughly $900,000. That 5% is $45,000 that are being taken out of the pockets of our beneficiaries to go through this process here. So what if Tom gets a trust? So what is a trust? Because people utilize the words wills and trusts simultaneously, and they're extremely different. When done correctly, a trust substitutes a will, meaning that a trust avoids probate court. So a trust is this entity that you create, this legal entity that you create that by contract that owns your assets and manages your assets for you while you're living. And then once you pass away, it manages and distributes your assets to your beneficiaries, whoever you have designated as your beneficiaries. Like I said, as long as it's funded and most importantly, updated, a trust will avoid probate court. So let's take a look at this a little bit, give you a better idea how this all works. So when we're looking again at those three buckets, we're funding the trust needs its own property. You update your beneficiary designations, so it's making sure that they're in alignment with your trust. And when you do all of these things, then your everything remains confidential. So like with a will, you file that with the court, that all becomes public documentation, and it identifies your beneficiaries and even how much money your beneficiaries are likely to inherit. But with the trust, as long as you do what you're supposed to be doing in your lifetime, nothing will be filed with the court or need court supervision. So I know this is kind of a creepy like graphic of this boy, but the focus is not necessarily on the boy, but the wagon. The wagon is the trust. And you'll see here in this picture, the house and the money is not inside of the wagon. If the boy were to pass away with the trust, the only person who could then pick up those assets and put them back into the wagon where they're supposed to be is a judge. So here, everything's all tucked in nice and tight, and it doesn't matter who's going to pick up the handle after this. I'll just pretend he's an adult because it sounds weird saying that. If he were to pass away or even become incapacitated, the next person that's designated in that trust to be the successor trustee just picks up the handle without a court order, and it continues to manage the assets. Finding conversation. So be prepared. We look under the hood of everything. So be prepared to have that kind of discussion as well. And a document alone is not enough. So that was with the example with that divorce case I was talking to you about, that they had a judgment. He had a judgment that said that life insurance policy was his, but because that beneficiary designation wasn't updated, it did not matter. So Tom is the biggest part of this story because he had a lot of different things going on. Let's talk about the Doe family. They have 2 minor kids. And so if you have any children, this is particularly applicable to you as well, but they also have some unique situations too. So don't phase out just because you don't have children. So what about the kids? So they were in a car accident and they have 2 little kids that were also in the vehicle. Now, if mom and dad could verbalize, because they are unconscious and they're taken to the hospital, they could verbalize who to call, it would be Nanny Nancy. See, again, with this alliteration, it's not that unique. Nanny Nancy. Nanny Nancy is a part of their lives. She's a part of their family. She knows exactly, that Tommy likes all this crust cut off and will only drink out of the purple cup, and that Samantha goes to ballet on Tuesday and she needs these ballet shoes and she only likes to go stand by her friend Susie, whatever the situation may be. Nanny Nancy is very much ingrained and loves these kids, and they love her too. So if mom and dad could talk, John and Jane, they would say, please just call Nanny Nancy. But they don't have any documentation that states that. So then what happens? They have a brother. Jane has a brother, Bob, who lives out of town. He works the night shift, and it's going to take some time for him to get to the kids. So what's likely to happen in this scenario? These kids need to be with somebody. They can't just be left at the scene. Their parents are no longer there. And law enforcement, when they show up in these types of situations, they have very limited options. And here in Southern California would be the involvement of Child Protective Services. So here, what we do, or what I do that's unique, is I have what's called a kids protection plan. It's not only planning for who's going to raise your kids if you can't, but who's going to look after your kids in the event of an emergency until those guardians get into place. So guardianship is equally about what happens to your kids in the event of an emergency, as well as who will raise your children if you cannot. And sometimes those are the same people, and sometimes they're not. Like for me, for my family, for example, our long-term guardians is my brother who lives in Phoenix. It's even if he were to jump on a plane, it's 45 minutes on the plane to get here. You have to factor in like flight time or the travel time at the airport, getting to the airport, then getting here, getting a car, driving to where we are. It's going to take some time. So it's having someone here locally that could get to my children, be with my children until my brother were to get here, and then figure out their next steps from there. Going back to Jane, John makes a recovery. He's up and about, but Jane's injuries linger and she's still unconscious. So as you could imagine, they're both getting sent down to the hospital, and ambulances and emergencies, like those medical bills are rising. One of the things that Jane has is a separate property account. She inherited $100,000 from her aunt when her aunt passed away. So John is just like, oh my gosh, we have, I'm getting ahead of myself, but I'll talk about the bank accounts in a second. So John, and talking about Jane's medical decisions. So you would think that John, being her spouse, would have absolute ability to make those decisions for her care. However, the law does not presume that your spouse is best suited to make those decisions for you. So in comes Jane's parents. Maybe her mom's name is a Karen. I'm just going to say a Karen, like not as you could imagine what that personality may mean. And I hope there's nobody here named Karen, but you know what I mean if that's the case. And they have conflicting opinions over the care of Jane. Who is going to make those decisions? And most importantly, who is the doctor or the medical staff going to listen to? And in this situation with HIPAA or privacy information, like the hospital might just, would say, hey, you guys can't figure it out. You need to go get a court order and then come back so we know who to take orders from, because this is getting out of hand. So without an estate plan or healthcare directive, who can make medical decisions on your behalf? The only answer to that is a judge. So here, going back to those bank accounts, so John's like, we got to take care of like our finances, they're getting out of control. I know what I'm going to do. I'm going to go down to the bank and I'm going to access that $100,000 and just like try to get us above water and focus on Jane getting better. He goes down there and he asks for access to that bank account, and the bank says, sorry, you're not on that account. And he's like, but it's community property. Yeah, we're married. What do you mean I don't have access to the account? You're not an account holder, so I can't give you any information or access to that account. So now we're in probate court over two different issues. Jane's not gone. She's very much living. She's unconscious. We have healthcare decisions. Who's going to make her healthcare decisions, and who's going to access and manage her finances? Again, Jane's mom's like, I should do it because that was my sister's money, and I don't like John, and I've always had an issue with him, and I think he's irresponsible. So again, it's who would the judge elect in this situation, the spouse or the mom, to be able to make these decisions on behalf of Jane? So how could we fix this in three different ways for Jane? One is executing a healthcare directive and a HIPAA authorization. I call HIPAA authorizations family diplomacy. And what does that mean? So even utilizing my own family, for an example, like my mom's not listed on my healthcare directive, not because I don't love or trust my mom. It's just because even if I told her what to do under certain circumstances, it'd be too difficult for her. But I have her on my HIPAA authorization, which would at least allow her to contact my doctor and get information firsthand, rather than it coming through my husband, and she would feel second fiddle. Like, it's my daughter, like I should be able to know this information. So that's what I mean by family diplomacy and how some of these documents can interplay with one another. A financial power of attorney. So this is all the incapacity documentation. And I think that every adult over the age of 18 should have at least these three documents. Financial power of attorney, you're appointing someone to act in your place in the event of your incapacity to do a wide variety of financial duties, like our activities, being able to access your bank account, being able to manage any property or any contracts or safe deposit boxes, or even file taxes on your behalf if that's necessary. They're able just to literally step in your shoes if you cannot manage your own affairs. The only person, so this is lesson number 3, the only person who can make these decisions if you don't have those documents is a probate judge in this scenario. So let's go to Mama Molly. She was that innocent bystander. So she did all the right things. So she had a trust-based estate plan. She has power of attorney. She has a healthcare directive, and she has a kids protective plan. So a protection plan. So she's taken to the hospital. Her husband's able to just focus on her care. Their successor trustees can even step in their place as they're unable to manage their affairs. The grandparents can assume temporary guardianship of the kids, like being able to take them to school, being able to take them to the doctor, and those kinds of things. She's got her power of attorney and her healthcare directive just in case, and nominating her husband to make her medical decisions on her behalf. She makes a full recovery, so that's the happy story here. She makes a full recovery, and then as she gets better, like everybody that stepped in her place just recede back to the background until they're ever needed again, in the event of her injury or once she passes away. So here's a quick review of all the important things we talk about. A will goes through probate. When funded properly, a trust avoids probate court. You must review your assets as a part of your estate planning conversation, looking over title and looking over beneficiary designations as well. If you have minor children, short-term and long-term guardians are both essential. So you might be asking yourself, do I need a lawyer? And that's always something people ask. So if the kids protection plan, for example, is something that's important to you, or you're like, wow, yeah, that's something that we need because I don't want that situation happening with our kids. I do have a website that has a lot of the documentation that you can implement for free. But you have to pay attention to it because you can print it out, but just because you print it out and sign it does not make it a legal document. A lot of them require either a notary or a witness. So as I mentioned before, like how much does this all normally cost the average home value in San Diego County being roughly like this was just
You're frozen.
oops,
I heard you for a split second there. While she's regaining her internet connection, I will just say the average house is not $900,000 here. It's probably over $1 million now. So it's a lot of money. If you're going to have a house that's 1.5 million or something, that's a lot of money you're handing over to attorneys.
yeah, sorry about that. My internet just went out. So when I last looked at the number, which was probably a year and a half ago, like it just shows how much the real estate market has changed. But yeah, so it's even more than that, as you were just saying, Cherie. So what I try to do is to incentivize people to get this done. So for the people here in California, I offer for attending this and taking time out of your day today a $250 coupon. And the reason for that is just because of procrastination. I know that if you go out with the rest of your day saying, I'll contact her office later, the likelihood of you actually doing that is very small. So to get that done, I offer this coupon here. Star can drop my calendar link in the chat box as well. If you have any questions, please do not hesitate. We'll open it up for questions as well. We try to make this a very easy process. What we do is we set aside a free complimentary meeting. We go through what your assets look like and specifically how it relates to probate court, and we talk about it, and then we fix it if that's something that you don't like. So as this was a quote I found from Benjamin Franklin, is that you may delay, but time will not, which I thought was just so applicable. And even what Amy was saying is this: we don't know when our last day will be, but planning and protecting our family and creating that legacy, as we mentioned before, I just think is so important. So as I mentioned, like for the guardianship documents, they are free and they are available here. I have a worksheet. I don't think it got put in the chat though. We can send that out to you guys and just give some feedback on the information you received, or if you have any questions that you're not comfortable talking about in the chat. And is to please utilize my calendar. I set aside the time so you can ask whatever questions in an environment where you feel secure. I do it online. I do it in person as well. Just whatever's easiest for you just to get this done. So does anybody have any questions? I know it's a lot of information that we went through.
We had one question come in while you were chatting. So Kelly, I believe is how you say her name, asked, how often do you need to update your trust?
That is such a good question.
Good
So
question.
the lack of updating, in my opinion, is the Achilles heel of estate planning, because most people assume once they get it done, they don't ever have to worry about it again. Like, I was meeting with a client or with a couple that dropped off their plan for me to look at before we met, and I could tell as soon as I opened it that it had not been opened since 1996, because it like cracked, the spine cracked. So what I do as a part of my practice is I meet with all of my clients once every 3 years complimentary. And what we're doing is we're going over all the choices that they made and looking at their assets. Because if you were to just look at your life like 3 years ago and look at the changes that you've made, maybe you've gotten a new job or jobs, your benefits have changed, your life insurance has changed, your retirement plans have changed, all of those need to be incorporated into your estate plan. So my practice is at least once every 3 years with all of my clients, just to make sure that whatever the goals are, we're always staying on top of them, and so that your estate plan is also evolving with you and your life as well. So that's a great question.
I think Patricia had a question too. Let me scroll back up. Okay, she just said she's currently in Arizona, returning to California in March. She needs to know what to do now. She has a plan for death, but not a will. And she has an informal plan with her cousin, and told she needs to wait. Informal with my cousin, told I need to disinherit my estranged son, or he will get everything as he's the next of kin.
Right. Well, so you have options. Like, certainly in Arizona, Arizona is also not a probate friendly state. I have a lot of colleagues in Arizona. So depending on how important that is to you, is to talk to an attorney in Arizona, and you can always update it once you move here to California. So that would be my recommendation, is it's better to have something rather than nothing at all, because if you are concerned with your son, your estranged son, inheriting everything, like you said, that is what would, assuming what you said, I don't have any more information than that, but that is a concern of yours, is certainly to get something in place sooner rather than later. But it also depends on the type of assets that you have, etc. So if you want, you could reach out, and I can always put you in contact with an attorney, and just let us know where in Arizona you are, and I can put you in contact with an attorney that can at least answer those questions.
Perfect. And then Chuck was asking, do assets need to have the trust? Do assets need to have the trust as the account name?
So it depends on the type of asset. So I always recommend that bank accounts should be in the name of the trust. Your house should be in the name of the trust. But then it gets very fact specific in terms of retirement accounts and life insurance as well. So that is just a really great conversation to have, like in the family wealth planning session. That would be the next step from here, just to discuss those options as well, and how that would all work.
Anybody else have anything? And you can
I
always.
just had a quick question. I hear so much about revocable trusts. Is that something that you recommend for people, or is a living trust the best option?
So that's a great question. Revocable living trust or living trust or family trusts, those are often all the same thing. They just have all different monikers. What's the different element is irrevocable trusts. That's something completely different. And those are not as common anymore, because so one of the things I didn't mention is estate tax. This may be shocking to most of you. California does not have an estate tax. I think it's just because we're taxed on everything else that they gave us a break. But there's a federal estate tax level or exemption. And right now it's super, super high. It's for an individual, it's $12.4 million. So anything above $12.4 million would be taxed at a rate of 46%. And so what an irrevocable living trust, it's a tool to avoid that 46% tax bill for anything above that exemption amount. So because it's so high, that's almost $25 million per married couple, that you don't see them that often anymore. But revocable living trust, family trust, those are generally all the same thing.
Can you explain what an irrevocable trust is? So my parents are in New York State. We're concerned with protecting their assets from the state in case, one is left and they go into a nursing home. So what is the downside of a irrevocable trust?
So just by the name itself, there's irrevocable, so you can't change it. So there's not that much flexibility with the irrevocable trust. And there's even Medicare planning trust. So if that is a concern, like you were just talking about with the cost of with long-term care or nursing homes and being able to protect your assets from the clawback rules of all of that, there's a state, there's called elder law attorneys that are specialized in that area to be able to craft certain types of trust to protect the assets from getting putting liens against for those types of programs, if that makes sense. But
Okay.
a irrevocable trust, they're utilized mainly for the avoidance of estate tax. I don't know, like in New York, what their estate tax is, if any. But that's when you see irrevocable trust. But like there's a Medicare planning trust for sure.
Okay, maybe you can give me a referral
Sure, absolutely.
somewhere. That'd be awesome. Thank you.
Yeah.
Let me just add a tidbit about the irrevocable trust versus revocable as a mortgage lender. Most loan investors will not allow you to vest in a irrevocable trust for mortgage purposes.
Okay.
Something to keep
That's
in
good to
mind.
know.
Anybody else have anything before we wrap up? All right, Colleen, thank you so much. That was
You're
a lot of
welcome.
information. I learned something from you every time we talk. So thank you. I really appreciate it. And I think, guys, if you learned anything from today, it's just don't delay. Start your conversations with people now. I know it's a hard conversation to have, but you've got to plan it out. I mean, I saw just very little of what Amy went through, and it was freaking heartbreaking to watch it. So just make sure you have the conversations with the people that you love, and feel free to reach out to me, Colleen or Cassie, if you have any questions. We're going to send the recording out to your email after we get it downloaded, and then I'm going to include a link on there. Don't feel obligated, but I'm going to put a link for the GoFundMe page for Amy and her 4 kids. So if you guys have any extra money, like $10, anything, everything adds up. I'm sure she would really appreciate it. It's a really heartbreaking thing to see somebody go through. So thank you for your time today, and we will get the recording out as soon as possible.
Thank
Thanks,
you.
everyone.
Thank you, everybody.
Thank you.
Have a great day.